he's pretending like, oh no, I can finally file a motion to dismiss. No, he literally talked about why he didn't file one before, even though it was suggested to him. And that was because it would have been expensive. Is this judge a Starker? Is he saying, why doesn't Destiny subpoena this person? Uh-oh. Uh-oh. He's speaking really fast here about sending pornography to a minor in April of 2022. Like, he's hopeful of, like, any positive news at this point. I'd say that's like a window into how well things are going. Okay, so the big thing that was going on, there's a couple big things going on in the Pixie case. I believe that the court transcript was sealed for 90 days, but also the motion for the court transcript to be sealed 90 days seems to have been said, like, until further notice, so that's a little weird. So, here we go, look at this, and we basically have, transcript of hearing held on this date. So, I believe today was the date. Transcript restriction set for, September 4th. So apparently yesterday, the transcript was supposed to get released. I'm guessing this right here, sealed until further notice, means it's actually docket entry 90 sealed until further notice. I'm guessing it's just going to stay sealed until something changes, right? But, so that was one thing that people thought was coming out today. Or yesterday, sorry, it didn't. But what did come out yesterday was Andrew Brettler doing a totally retarded response. Maybe not retarded. I actually haven't read it yet. But Andrew Brettler responds to Pixie trying to sanction Destiny for reading that transcript live on Food Shop's stream. And we get a ruling, okay? Order granting 107 motion for leave to file amended complaint. This, okay, if you guys remember, if you've been following it all, is the subject matter jurisdiction stuff. So you needed this complaint amended because realistically, there's probably an argument that there's not enough proof to pass a summary judgment a motion for summary judgment, okay? They're basically, Destiny's team has been bringing up that this court doesn't have subject matter jurisdiction repeatedly. Under the law, the federal law that Pixie is suing Destiny for, she needs a violation that happened after October of 2023. The actual Rose leaks, sending Rose the Pixie video was done in April of 2023. Sorry, 2022. October of 2022 and April of 2022. So it was done in April of 2022. So it's about 6 months before the law was passed. And because of that, technically under Cardi, there's no bulletproof evidence that Destiny sent the video after Cardi was passed. They're arguing that because of that, because this can't be considered a violation of Cardi because it happened before the law was passed, and with all federal laws, they don't go backwards. They don't, they don't go into the past, however you put that in terms of legal things, but they're not retroactive. So they need an instance of some violation from after October of 2022. The Abby testimony puts a violation in November of 2023, I think, right? Almost a full year after. So that gets them past a motion to dismiss because they don't have subject matter jurisdiction, if they can get that into their complaint. This right here is an order on the motion for leave to file an amendment to the complaint. The judge has supported that. The judge has said, yes, you can file your complaint. Sorry, you can amend your complaint. So we'll read this because there are some good memes in here, okay? Some good memes. We get some memes coming. Of course, we need a costume change real quick. Of course, we're going to put the judge's wig on, okay? Let's go. All right. So, United States District Court, Southern District of Florida. Order on motion for leave to amend complaint. This matter is before the court on plaintiff Jane Doe's motion for leave to file an amended complaint. Docket entry 107. Defendant timely responded, docket entry 109, and plaintiff timely replied, docket entry 110. After careful consideration of the motion, response, reply, relevant authority, and for the reasons discussed below, plaintiff's motion for leave to amend their complaint is granted. So this is basically going to make them, if they can amend it, include this, I believe they'll mostly be immune to a motion to dismiss, right? I think they mostly are immune to a motion to dismiss at this point. Background. This case stems from what plaintiff alleges is defendant's wrongful dissemination of a video of a sexual nature, the video, involving both Ms. Doe and Mr. Bonnell. Defendant, for his part, alleges the situation was more complex in that both plaintiff and defendant repeatedly shared similar materials involving third parties with each other, and that the practice, in effect, extended to other individuals. Docket entry 42 at 8-9. It was, then, one of those other individuals, Rose, whose Discord account was allegedly hacked, which resulted in the leak of several videos of a sexual nature involving defendant, including the video. Example is docket entry 42-1. Presumptively, due to the nature of the case, the parties and their counsel have proceeded to throw the proverbial kitchen sink at one another. This has resulted in a litany of briefing before the court. These motherfuckers be yapping. They're yapping. Of particular focus here is plaintiff's motion for leave to file amended complaint, docket entry 107. In so filing, plaintiff is seeking to preemptively address what defendant characterizes as a lack of subject matter jurisdiction. In terms of briefing, defendant has never proactively filed a motion challenging the court's subject matter jurisdiction over the case, but instead has raised it in response to several of plaintiff's motions. See, for example, docket entry 42 at 14, docket entry 109 at 4. I think these would be paragraphs. Defendant's argument as to the lack of subject matter jurisdiction is as follows. Plaintiff made the understandable mistake of misinterpreting evidence regarding a Discord chat where defendant shared the video with another individual as showing that the conversation took place in October 2022, when it actually took place in April of 2022. Docket entry 42 at 14. The singular federal law under which the plaintiff is claiming federal question subject matter jurisdiction, 15 U.S.C. 6851, this CARDI civil action relating to the disclosure of intimate images, or CARDI, only went into effect on October 1st, 2022, and is not one that applies retroactively. Docket entry 109 at 4. Hence, says defendant, CARDI cannot be invoked here, and there is no remaining federal claim giving rise to the court's jurisdiction. Examples at paragraphs 4 and 5. Therefore, any amendment to the operative complaint would be futile for want of jurisdiction. ID at 5-7. I don't know what those references are. It's saying based on some former shit. Okay. Oh, do I need to... Hold on, I need to zoom out a little bit. There we go. That's better. Better for you guys to see. Okay. In response, and though not conceding such an understandable mistake took place, plaintiff now seeks to preemptively address any possible jurisdictional deficiency by amending her operative complaint to add allegations regarding the wider dissemination of the Google Drive, where defendant is alleged to have kept a trove of videographic material of a sexual nature, including the video. Docket entry 107 at 3-4. This, in addition to a prior allegation from May 2025, the defendant also sent the video to Abby MC, see docket entry 48. And because, says plaintiff, the Google Drive was consistently available to many individuals and that availability continued through the period where CARDI took effect, CARDI indeed applies. This court has jurisdiction to hear the case, and amendment is not futile. So this was a big one where they were, I believe they thought they could dismiss based on this stuff not happening. I think he starts to address some of the other arguments they've made and some of the other things. The Google Drive is getting audited. This Felcher is so cooked. I don't know if that's what this means yet. I don't. It will depend. But that seems like it could be what it means. So that would be not great. Destiny getting aped? Brutally so. Brutally so. In response. Oh, whoops. We're down here. Applicable principles in law. The jurisdiction of federal courts. So they have jurisdiction. Amendments to pleadings, federal rules of civil procedure, blah, 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 blah. I actually don't care about any of this. This is all just legal mumbo jumbo. Do you want me to read this? It's just going to be references to, like, why they have, right? It's going to say, based on these principles in law, I'm going to allow this. Isn't that just Pixie's argument, not the ruling? No, this is the ruling. This is not Pixie's argument. This is the ruling. This is them saying, yes, we will allow you to amend the complaint. This is the order on the motion. The order on the motion, you know? Maybe Riles an AI summary? Well, this is just not going to be relevant. It's not going to be... it'll be relevant. I'm just going to read, fuck it. Jurisdiction of federal courts. Federal courts are courts of limited jurisdiction, meaning they only have the power to provide a forum for some, not all disputes. See Morrison v. Allstate. Federal courts have limited subject matter jurisdictions, or in other words, they have the power to decide only certain types of cases. A district court can hear a case only if it has at least one of three types of subject matter jurisdiction. 1. Jurisdiction under a specific statutory grant. 2. Federal question jurisdiction pursuant to 28 U.S.C. section 1331. Or 3. Diversity jurisdiction pursuant to 28 U.S.C. section 1332A. This is the citation. Citations and internal quotations omitted. A federal court not only has the power but also the obligation at any time to inquire into jurisdiction whenever the possibility that jurisdiction does not exist arises. So if they didn't have jurisdiction, it would be their responsibility to state so, and they are supposed to examine this often. If the court determines at any time that it lacks subject matter jurisdiction, the court must dismiss the action. Amendments to pleadings. Federal Rule of Civil Procedure 15A governs amendments to pleadings. A party may amend any pleading once as a matter of right before a responsive pleading has been filed or within 21 days after serving the pleading if no response pleading is allowed. See Federal Rules of Civil Procedure 15A1. In all other situations, the amending party must obtain written consent from the opposing party or leave of the court to amend the pleading. See Federal Rules of Civil Procedure 15A2. The rule declares that leave to amend shall be freely given when justice so requires. Okay, so they're basically saying that if you have like a solid reason and to obtain justice we need to amend the pleading, we'll never block it. If the underlying facts or circumstances relied upon by the plaintiff may be a proper subject of relief, he ought to be afforded an opportunity to test his claim on the merits. See Foman v. Davis. Any amendments leading to a modification of the required pretrial scheduling order are subject to a good cause standard of scrutiny. See Federal Rules of Civil Procedure, Parts 16b4. Parts? Oh no, Federal Rules of Civil Procedure, 16b4. That means that after the deadline for amending pleadings set forth in a scheduling order is passed, the party seeking the amendment must show good cause on why leave to amend the complaint should be granted. See this case. District Court need not allow an amendment where allowing the amendment would cause undue prejudice to the opposing party. Okay. Of course, the grant or denial of an opportunity to amend is within the discretion of the District Court, but outright refusal to grant the leave without any justifying reason appearing for the denial is not an excuse of discretion. It is merely abuse of that discretion and inconsistent with the spirit of federal rules. In the absence of any apparent or declared reason, the leave sought should, as the rules require, be freely given. Substantial reasons justifying a court's denial of the request for leave to amend include undue delay, bad faith, or dilatory motives on the part of the movement, and repeated failure to cure deficiencies by amendments previously allowed. See this case. Burger King versus Weaver. Damn. Additionally, a district court may properly deny leave to amend when an amendment would be futile. Analysis. The question of whether we have subject matter jurisdiction is not so clear-cut as the parties would have us believe. Accordingly, each party accuses the other of not producing any evidence to support their respective claims as to when defendant disseminated the video and to whom. Docket entry 107 at 4, despite defendant's lack of corroborating evidence for this contention. Docket entry 109 at 4, plaintiff has produced no admissible evidence to demonstrate otherwise. As to plaintiff's allegations that defendant transmitted the video to another individual, ABMC, after the effective date of Carty statute, defendant argues that ABMC should have testified at an earlier June 3, 2025 hearing before the court that touched on, among other issues, subject matter jurisdiction. Docket entry 109 at 5. Defendant, for his part, leans on his declaration as to the date formatting the Discord chat primarily at issue. Plaintiff's mistake as to the Discord chat having occurred on October 4th, 2022 is understandable. In a screenshot of the transmission, the date of the communication appears as 10/04/2022. See Bunnell Declaration, paragraph 9, example C. However, the date is reflected using the European time zone as based on docket entry 42 at 14, but Mr. Bunnell's declaration then states that, based on information and belief, I have not sent the video to anyone other than Rose. I certainly have not sent the video to anyone since I sent the video to Rose on April 9th, 2022. Attached here to, as Exhibit C, is a true and correct copy of my Discord exchange with Rose, dated April 9th, 2022, beginning at 8:06 p.m. Eastern. On page 2 of the exhibit, because it is a screenshot from Rose's side of the conversation, the date of the transmission is reflected in European time format, day, month, year. The timestamps on page 2 of the exhibit reflect that Rose was corresponding from a time zone 5 hours ahead of me in Miami, Florida. It was April 10th, 2022 at 1:06 a.m. UTC when Rose and I began corresponding regarding the video. Okay, so this is, people point this out as like, Destiny is basically saying, oh, I think she was like in the UK or some shit, right? Because of the UTC time zone. I don't know if you can really make that argument. Defendant also argues that plaintiff's current allegations with respect to when ABMC received the video from defendant and corresponding proposed amendment to the operative complaint are contradictory. Compare docket entry 48 at 1. ABMC describes defendant as sharing a sexually explicit video of himself and the plaintiff via Google Drive link on November 3rd, 2023, with docket entry 107 1, paragraph 14. Sometime in March 2023, Bunnell began messaging with a fan of his on Instagram with the screen name ABMC. Over the course of their ensuing relationship, Bennell sent Abby MC multiple sexually explicit videos, including the video, through his Google Drive link. 15. Sometime after receiving the video, Abby MC messaged a friend of hers and told her part leans on his declaration as to the date formatting the Discord chat primarily. Told her friend that Bennell had sent her a sexually explicit video of the streamer Pixie, referencing the exhibit text message at docket entry 86-1. To that end, defendant alleges that the proposed amended complaint now asserts, as a ploy to establish jurisdiction, that sometime before November 3rd, 2023, defendant sent the link to Abby MC. Docket entry 109 at 7. It merits noting that Abby MC submitted a signed declaration attesting to the transmission of the video occurring on or about November 3rd, 2023, docket entry 77, docket entry 48, docket entry 76, that both plaintiff and defendant at times mischaracterized Abby MC's on or about testimony as occurring on November 3rd, 2023, does not change her testimony, but does add necessary context. In other words, the alleged transmission of the video and a message to a friend could well have been two chronologically separate events that both align with Abby MC's on or about testimony. The text of the chat snippet at docket entry 86-1, dated November 3rd, 2023, is consistent with this. By the way, Destiny sends me sex tapes all the time, and he blah, 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 blah. So the alleged transmission of the video could indeed have taken place on or about November 3rd, 2023, without making the allegations inherently incongruous. Okay. Let's continue. We're continuing on from the previous paragraph, which is about the timestamps, okay? Docket entry 42-1, paragraph 9, emphasis in original. And for all of defendants' protests that Abby MC should have testified at the hearing, noticeably absent from defendants' arguments, generally, regarding subject matter jurisdiction and testimony, is testimony from Rose that would corroborate defendant's characterization of the Discord chat in his declaration. A characterization that incorporates in Exhibit C a screenshot from Rose's Discord account that plaintiff could not have obtained on his own from his side of the conversation. Thus, as it stands at this stage of the case, the evidence purportedly establishing a definitive timeline as to what defendant did or did not do, when is murky at best. Bro, is this guy a fucking snarker? Is this judge a snarker? Is he saying, why doesn't Destiny subpoena this person? Uh-oh. 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 Oh, also, by the way, I just kind of hope that they file, so you can file errata to update things, right? You can file errata to update filings. I believe in the amended complaint, they do list Rose's age as 19. I do believe they should update that. We have very clear information now to say she was 17. I think that should be on the record, as he reached out to this 17-year-old to sex them. Right? I think that's pretty clear. That's pretty obvious. That should be a matter of public record. Absolutely. So Pixie's team, I don't know if Pixie's watching this. Okay, if Pixie's team is watching this, update, file, whatever you need to file to update that to say, oh, small error, we listed her age as 19, her age is in fact 17. Let's go. Let's go. The Cabal judge is in cahoots with JSTLK and Teoria. Okay, well, yeah, everybody's in the Cabal. In any event and under the circumstances, we need not reach a decision on jurisdiction today. Defective allegations of jurisdiction may be amended upon terms in the trial or appellate courts. 28 U.S.C. 1653, see Cohn v. Burlington, assessing whether the Court of Appeals has subject matter jurisdiction, and noting that plaintiffs are usually able to amend their complaint even on appeal when such jurisdiction is deficient. This provision, like Rule 15a, should be liberally construed. Leave to amend should be freely granted when necessary to cure a failure to allege jurisdiction properly. At this juncture, we need not reach an answer as to jurisdiction because, even if the plaintiff's jurisdictional allegations were initially defective, the proper course in this instance would be to grant leave to amend. So they're basically saying, without actually testing subject matter jurisdiction, I'm not making a ruling on that. I'm going to say that I'm going to give them leave to amend because your argument against leave to amend is that they don't have subject matter jurisdiction. I don't have to solve that. If you truly believe they don't have subject matter jurisdiction, then file to dismiss, okay? File to dismiss, motherfuckers. Based on the record before the court, there is nothing to suggest plaintiff's motion is the result of undue delay, dilatory motive, or is otherwise in bad faith. See, 2007 WL, this number. It is worth noting that plaintiff is incorrect that she timely filed her motion to amend, for which the deadline per docket entry 23 was July 6, 2025. Docket entry 23 at 1, docket entry 107 at 3. That said, plaintiff filed on July 7th, 2025, and we are loath to consider that single day as undue delay or dilatory motive. And it is true that defendant has been raising the question of subject matter jurisdiction in various responses to plaintiff's motions, and thus cannot be surprised at, and should not be unduly prejudiced by, plaintiff's request for leave to amend. Oh, so basically the only real cause for not allowing amendment would be that he would be prejudiced, but it's like, you've been making this argument, right? Basically, for amended complaints, judges tend to favor allowing them since it basically lets the plaintiff make the best version of their case and the defendant oppose the strongest version with their strongest defense. Well, Free Pie, yes. Sorry, I'm reading Free Pie's message here. Yes, I think it's basically just like, why would we make you refile this, right? Like, obviously, they've gone through a bunch of administrative effort to get this through the courts already. Why would they make you refile it and, like, make everybody, like, we've already spent judges' time on this. Just amend the complaint and we'll continue. It's not like it's a totally different case. It's just, especially for subject matter jurisdiction, right? So it's worth noting that she doesn't have dilatory motive. I will say, I believe that Destiny's team argued this multiple times, that she's just spamming. Destiny's argued this colloquially as well, that she's just spamming motions and she doesn't want to do anything, and she's way behind on this and she didn't say anything about it, and like, they're just fucking with me. But the judge says, no, she's not fucking with you, and this is like fine, and you kind of expected this. You've been motioning to say that she doesn't have subject matter jurisdiction. You can't be shocked that she's filed for leave to amend her complaint, obviously. And it's true that the defendant has been raising this question, blah, 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 so can't prejudice him. See docket entry 42 at 14. The parties have even mutually elected to somewhat pause discovery pending the court's resolution of plaintiff's motion for protective order. Docket entry 82, docket entry 107 at 3, number 1. Thus, as leave to amend should be freely given in the absence of substantial reason to deny leave, Bryant 252 F3D, I don't know what this means, F3D 3rd District or something, at 1163, plaintiff's motion for leave to file her amended complaint is granted. Granted, okay? It's all good. They made it work. Should defendant believe, after the filing of plaintiff's amended complaint, that this court still does not have subject matter jurisdiction, defendant is free to file a 12b1 motion or otherwise generally respond to plaintiff's briefing, arguing as much. Ha 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 ha. So this is him saying, if you actually believe she doesn't have subject matter jurisdiction, if you want a ruling on that, because you haven't filed anything, then actually file something. It's like, even if she didn't have subject matter jurisdiction, which this complaint solves, or sorry, amending should solve, unless there's like evidence proving otherwise, you should just file to dismiss. I believe Destiny's had the ability to file to dismiss this whole time. I actually believe it's possible that Destiny fucked himself, right? I don't know when they started talking to Abby or when they figured this out, but it's possible that if he filed to dismiss instantly, they might have just seen that, got that through the court, and been forced to reply with no response from Abby. Like, I don't know when Abby came in, but it was like quite a bit later. They might not have been aware of Abby until like weeks or months after the initial complaint was filed. And I think the reason he gave for not filing one was it was expensive. The judge was in the Kiwi Farms thread, case dismissed. Oh no, I hate Kiwi Farmer judges. Conclusion, for the foregoing reasons, plaintiff's motion for leave to amend is granted. Docket entry 107. Plaintiff shall promptly file her first amended complaint on the docket. Done and ordered in chambers at Miami, Florida, this 4th day of September, 2025. Edwin G. Torres. Eddie Torres. Well-known Kiwi farmer, Eddie Torres. So what do we got here around this? There's the Andy B thing as well. I think there was like some zip cope on this, wasn't there? He talked about it twice. I think there's a couple good clips on this. Let me see. I think Ryle sent me something here. Starting timestamp on YouTube.
Okay. So they amended it, but they still provided zero evidence. Guess the magistrate can throw it out now or what? Well, now, I think now we could either reply or we could do a motion to dismiss. I think now we try to do a motion to dismiss. Basically, the only thing now is they're trying to say that now they've walked back a little bit. The date on the sending the file to Rose, they walked back on that and they're saying that the debate is now in contention.
Wait, what?
Is that the word I'm looking for?
They walked back on that. Did Pixie's team file more? I thought this is just based on I think the judge just ordered something. I thought the only change here is the judge made their order. What did... Huh?
It's not. I think that plaintiff's own filings, like in their own filings, there are pictures.
Oh, right. Yes, Free Pie. This is what it is. So the Andy B filing, which is a... So there's one other thing here. Do I have court listener up still? I don't. Hold on. Court listener, Dove Benel. Okay. So we go to the bottom of this. There is the response in opposition to plaintiff's motion for order to show cause why defendant should not be held in contempt. Request for sanctions and injunctive relief filed by Stephen K. Bennell II. So Pixie's team basically said this retard went and read the sealed transcript verbatim on a stream. Can you not? Can you not? Did you see the food shop's bombshells? No, did not see those. There's a footnote in the amended complaint saying they were unsure when the messages to Rose were sent. Oh, they filed their amended complaint now, didn't they? Yeah, they filed their amended complaint. They need to file an errata for this and say, oh, we fucked up, and just make sure they tweak Rose's age to 17 here. There's also a quote from Brettler filing saying Pixie is the one talking about the case all the time. Well, she does talk about the case a little bit, but just not anywhere near. Oh, the Brianna Wu stuff. Is that really a bombshell? Bro, it's so crazy. The entire world is all collaborating against Destiny. There's like a massive cabal. Despite, you know, all of us totally fucking hating Brianna Wu. She's also in the cabal. Did you guys realize that? She's also in the cabal. No way. No way.
Pictures
Anyway.
of them looking at dates that say like 27-05-. So like it's pretty, these are European dates, I think by plaintiff's own evidence. So the only thing that it'll come down to is whether or not the what goes on with this Abby person, I guess, is the only thing. The mysterious Abby MC, whoever that is. Did you not motion to dismiss the whole time?
So
We could have filed a motion
mysterious.
to dismiss on the initial complaint, but the problem is it should have survived. Like they had a lot of claims and accusations in there. But now that we're through this a bit, they amended their complaint super late.
Just to be clear, they had a chance at motion to dismiss before this. As far as I know, the judge didn't take their argument that Abby should have testified seriously. He said, why don't you go get Rose to testify, right? Like, there's, like, essentially nothing he's saying here is accurate, right?
They had a lot of claims and accusations in there. But now that we're through this a bit, they amended their complaint super late. They haven't provided any evidence of...
One day late, and the judge literally said we don't think it's with undue delay. So that's already, the judge has already given the court's perspective on this. It was not late.
any of the other random things that they've had in there. They threw like even more wrong, dumb shit. But at this point, I figure now it's just beneficial to me. If you just want to load it up with a bunch of stupid stuff, it's good for me, I guess.
Dude, the cockiness is so funny. Like, it doesn't matter what actually happens in the case. He's like Andrew Wilson. Like, just there's no connection to reality, right? Just zero connection to reality. It's great times.
But now it's just beneficial to me. If you just want to load it up with a bunch of stupid stuff, it's good for me, I guess. But the only thing that matters that it all comes down to now is the Abby stuff.
I don't think that's true, actually. I think they amended something with the Google Drive saying the Google Drive was persistent through the date. I actually don't think it all comes down to Abby anymore. Right? That they're saying there's evidence of this like Google Drive or something. And I think that's amended and added to the complaint.
Yeah. You can file for dismissal. I mean, like, when a motion to dismiss, you're looking at the pleading and you're accepting it.
Oh, wait, this timestamp is only from today. I thought the Zip Cope was yesterday, wasn't it? Yeah, we missed the Zip Cope. Hold on, I've got like Zip Cope somewhere. Zip came on and talked to Destiny about how it was like actually good for them. Hold on, this is today. I need the Zip Cope. Where that Zip Cope at?
They got their motion, but it's pretty good for you.
Presumptively, due to the nature of the case, the parties and their counsel have proceeded to throw the proverbial
Yeah.
kitchen sink at one another. This is resulting in
I saw that.
Who's
You gotta read it after. You gotta read it
Should
after.
I?
Holy fuck.
Yeah, I feel like 90% of the motions have been filed by them. I'm pretty sure they have been, okay? Jesus.
Yeah.
Okay, maybe I'll fucking read it. Did you read the whole thing? Is it good?
I'm pretty much finishing it. It's
Brettler spams some replies too. Brettler's got to pad out those billing hours, okay? So his complaint being amended mean that anyone he sent the Google Drive link to is subject to discovery. Sorry, I'm mad out of my field here. No, I mean, I think it's his Google Drive would just be open to discovery. Possibly. But I think they'd have to have evidence of this. The thing is, I don't think they have evidence of this because I believe that they literally unless they have some other evidence they haven't submitted. But they literally are just alleging this. And if they allege it off of the Rose stuff, the Rose leaks, those were done over Discord. And I thought they were alleging it off of the leaks done over Discord. So
they got their motion, but it's pretty good for you.
Oh yeah. Oh no, it is because okay, okay, I'll go through this. All right.
Yeah. Don't.
The matter is before the court on plaintiff.
I don't know what this is. I guess most people just don't really read this stuff or look into it, right? Like, oh no, it's really good for you. Don't mention. It's like, what are you mentioning?
Plaintiff, don't read it.
Why wouldn't you want to just like talk about why your case is strong? I guess I don't know.
No. Whatever.
Yeah. The matter is before the court on plaintiff Jane Doe's motion for leave to file an amended complaint. Defendant timely responded, and plaintiff timely responded after careful consideration of the motion. Response, reply, relevant authority.
Okay, why the fuck did I read this? If I was just gonna go over this, fuck.
For the reasons discussed below, plaintiff's motion for leave to amend her complaint is granted. So a motion to amend the complaint just allows them to add.
Okay, give me a second. I'm gonna use the bathroom, get some water really quickly. I might get caffeine actually, because we got 2 more hours. I'll get caffeine.
To the
I'll be right back.
complaint. I was gonna go back and look, but I think they just want to add the
ABMC.
Yes.
ABMC and
which is what
Google
they're.
Drive.
Wait, what? Oh yeah.
ABMC and the Google Drive
Yeah.
thing.
And that second one has got some. Wait, hold on.
Yeah.
Can I meme for 1 microsecond? Hold on.
Oh boy.
It's funny because a hater DM me this, but hold on. I have a question. Because it wouldn't do that, would it?
You're probably right, but it I don't think it necessarily matters.
Well, they would have to. I think it would.
Well, because they're saying that with.
Yeah. Oh well, if they try to incorporate the Discord thing, but they'll never win on that. Even the drive link, I think there's already precedent that argument is stupid. But on the, oh well, but that doesn't matter. Hold on.
I agree it doesn't. But
well, I'm saying no. I'm saying for her in particular.
Yeah, but they're just using it. But I think because
they want to use the drive argument because they don't. That means that everything rides on.
Yeah, but the idea is that if it's true, then it existed before.
Is that even necessarily true? How would they even know that? They'd have to prove that.
That's their
That's retarded. Oh, maybe I'll have to go through and reread their motion. Then. I don't know. Or I mean, I feel like I probably read it before. Okay, sorry. All right.
True.
Anyway, we're back here. Okay. This case stems from what plaintiff alleges is defendant's wrongful dissemination of a video of a sexual nature involving both Ms. Doe and Mr. Bonnell. Defendant, for his part, alleges that the situation was more complex and that both plaintiff and defendant repeatedly shared similar materials involving third parties with each other, and that practice, in effect, extended to other individuals. It was then one of those other individuals, Rose, whose Discord account was allegedly hacked.
So if I had to guess at what they were discussing there, I feel like they're discussing the make available or continuous publishing element, right? I think that's probably what they're talking about there. And like, I think that it sounded like Destiny thinks that shouldn't matter, and it should just matter when you like originally sent or something. But it would depend, I suppose, on like if you could do access logs and shit for the Google Drive, right? I don't know. I think that's what they're discussing
in the leak
there.
of several videos of a sexual nature involving defendant, including the video. Presumptively, due to the nature of the case, the parties and their counsel have proceeded to throw the proverbial kitchen sink at one another. This has resulted in a litany of briefings before the court. A particular focus here is plaintiff's motion for leave to file amended complaint. In so filing, plaintiff is seeking to preemptively address what defendant characterizes as a lack of subject matter jurisdiction. In terms of briefing, defendant has never proactively filed a motion challenging the court's subject matter jurisdiction of the case, but instead has raised it in response to several of plaintiff's motions. Defendant's argument as to the lack of subject matter jurisdiction is as follows. Plaintiff made the understandable mistake of misinterpreting evidence regarding a Discord chat where defendant shared the video with another individual as showing that the conversation took place in October 2022 when it actually took place
might have to speed through
images,
the
not one that applies
actual-
retroactively. So as I said before, we don't have diversity jurisdiction. We're both in the same place. The proper venue, proper jurisdiction would be the Florida court. This federal law is the only thing that gives subject matter jurisdiction to allow it to be in federal court. And also all of the underlying things that she's trying to say are unhinged and actually fucking stupid. So like they require like malicious intent. So this subject matter jurisdiction question is paramount. It's the most important question that we're addressing right now. Therefore, any amendment to the operative complaint would be futile for want of jurisdiction. In response, and though not conceding that such an understandable mistake took place, plaintiff now seeks to preemptively address any possible jurisdictional deficiency by amending her operative complaint to add allegations regarding the wider dissemination of the Google Drive, where defendant is alleged to have kept a trove of videographic material of a sexual nature, including the video. DE 107, this in addition to a prior allegation from May 20.
I'm not sure I've ever... Man, I don't really know if that is... I know this existed. Destiny talked about it existing. I know for a fact that he did share Google Drive folders with people that had all, like, a bunch of stuff in it. I don't know if he shared the same Google Drive link with everybody all the time, if he just had like an open Google Drive where he could share with anyone. I knew that. No, I was shaking a shaker cup with like caffeine mixed with water, like caffeine powder, flavored powder stuff. But I do know he shared Google Drive links. I don't know if it was like everything. I have no idea exactly. So it's interesting. I think they could easily get evidence of this that Destiny, like I think that exists. Like people who would testify that he sent them Google Drive links instead, and like Drive is in like the folder, not a file, but a folder with like a bunch of videos in it. I don't know if that included the Pixie thing. I have no idea. I feel like that if they have that evidence, they should be able to go through. Yeah.
2025, the defendant also sent the video to Abby MC, and because, says plaintiff, the Google Drive was consistently available to many individuals, and that availability continued through the period where CARDI took effect, CARDI indeed applies. This court has jurisdiction to hear the case, and amendment is not futile. Would be that's
what they're saying.
What?
You understand what the judge is saying here?
What do you mean? They're just laying out the arguments from both sides?
Oh, kind of, yeah. Well, they're saying that it's true what plaintiff is saying. It is kind of so like it doesn't matter if they amend the complaint because either it's just adding to the whether jurisdiction is there.
Yeah. Wait, what? The judge is just walking through the judge is summarizing what why the plaintiff wants to amend the complaint, right?
Well, the last part they're agreeing with the plaintiff. They're granting it. Right?
It'd be reasonable to assume that Rose's videos could have been on the Google Drive and also accessible by anybody. I don't know. Like I've never heard of. I don't know if Destiny kept stuff with just other people in the same Google Drive. I don't know if I've heard of that. I don't know if I've heard of that.
And because, says plaintiff, the Google Drive is consistently available to many individuals, and that availability continued through the period where CARDI took effect, CARDI indeed applies, semicolon, this court has jurisdiction over the case, the amendment is not futile. I don't know if the court's making a determination at that point. I think these are just claims of the plaintiff, right?
They're going to get to it, but yeah,
sure, they might, yeah. That would be a thing that we would fight on, because the case law on that is like clearly cuts in our direction, and that would be a big change.
But all they're saying is that the
I don't know if that would be a big change if he was making the folder available to people, right? Those would be every time he's sharing the folder. I don't think just the folder existing is proof of continuous publishing, but then you would need access to all of his Discord DMs looking for other instances of sharing that same folder link, right? I think that's the big deal.
The amendment isn't futile, so they're gonna get to it later.
Yes, Cam the Jellyman. Yes, that exists with I believe that is Richard Lewis and Dan. And Destiny's also talked about how he's a big Google Drive of news.
They're saying the amendment wouldn't be futile.
At the very least, I mean, it would survive the pleading stage, right?
Wait, did I say Richard Spencer or Richard Lewis? I meant Richard Lewis, but I might have said Richard Spencer.
Right? Because you have to assume it's true. That's true. Yes. Okay. Sure. So agreed insofar as it would prima facie make the case. It would survive, I guess, a motion to dismiss because it would satisfy the jurisdictional aspect. That's true. Sure. Okay. Applicable principles and law. The jurisdiction of federal courts. Federal courts are courts of limited jurisdiction, meaning they only have the power to provide a forum for some, not all disputes. Federal courts of limited subject matter grant for pleading or legal laws and the discretion on the party.
They should just let them amend it. Because if it's true, then it would be the subject matter jurisdiction. It wouldn't be.
Kind of, yeah. You assume, yeah, as assumed to be true, but if true, then sure, yeah. Amendments to pleadings. Wait, analysis. Question of whether we have.
So I think Zip right there explains why this will survive subject matter jurisdiction, right? Like a motion to dismiss. Because for a motion to dismiss, you go, actually, even if what they said was true, they wouldn't have like subject matter jurisdiction here. This is the wrong venue for this. That's how they're trying to dismiss. But if it is true, they do have subject matter jurisdiction. So
okay, analysis. All right. So here they're basically just saying that like basically as long as the plaintiff isn't like super jerking around or whatever, like you should generally be given the opportunity to amend your complaint at least one time.
And if the stuff that they're trying to amend is true, then they should just let them amend it. Because if it's true, then it would be the subject matter jurisdiction. It wouldn't be.
Kind of, yeah. You assume, yeah, as assumed to be true, but if true, then sure, yeah. Amendments to pleadings. Analysis. Question of whether we have subject matter jurisdiction is not so clear-cut as the parties would have us believe. Accordingly, each party accuses the other of not producing any evidence to support their respective claims as to when defendant disseminated the video and to whom. Despite defendant's lack of corroborating evidence for this contention, plaintiff has produced no admissible evidence to demonstrate otherwise. As to plaintiff's allegations, the defendant transmitted the video to another individual, Abby MC, after the effective date of the CARDI statute. Defendant argues that Abby MC should have testified at an earlier June 3rd, 2025 hearing before the court that touched on, among other issues, subject matter jurisdiction. Let's see. Defendant also argues that plaintiff's current allegations read when Abby MC received the video from defendant corresponding proposed amendment to the operative complaint Arc 3rd with message to a friend of hers and told her, Jesus Christ, this footnote. Oh my God.
All this part says is we don't know the exact date that it happened.
Yeah.
But it doesn't matter. It would have to be after the.
To that end, defendant alleges the proposed amendment complaint now asserts as he ploy to establish jurisdiction, on the chronological system, transmit action. Okay, chat having occurred on October. For his part, leans on his declaration as the date formatting. Of dates here, but that'd be nice. Okay, defendant, for his part, leans on his declaration as the date formatting of the Discord chat primarily at issue. Plaintiff's mistake as to the Discord chat having occurred on October 4th, 2022 is understandable, and a screenshot of the transmission of the date.
Hold on. Does he skip? There's no way he skips. right? There's no way he skips. Oh, no, he doesn't.
The chat
He
says
doesn't
that's quickly
skip.
like
He
one
doesn't
failure.
skip.
Wow, be nice. Okay, defendant, for his part, leans on his declaration as the date formatting of the Discord chat primarily at issue. Plaintiff's mistake as the Discord chat having occurred on October 4th, 2022 is understandable, and a screenshot of the transmission, the date of communication appears as 10/04/2022. However, the data is reflected using the European time zone. The response circulation then states that, based on information, I believe I haven't sent the video to anyone other than Rose. I certainly have not sent the video to anyone since I sent the video to Rose on April 9th, 2022. Attached here to his Z is a true and correct copy of my distribution dated April 9th, 2022, beginning at 8:06 p.m. on 2H2 exhibit because it is screenshot.
He's speaking really fast here about sending pornography to a minor in April of 2022.
Rose's other conversation, the date of the transmission is reflected on European.
Dude, he's speaking so fast.
On page 2 of the exhibit was April 10th. When Rose and I began corresponding regarding the video. Oh, they should say April 9th. Oh, they might have mixed up the... Oh, no, wait. It was April 10th, 106. Oh, no,
April
this was correct.
10th in UTC.
Okay. Nice.
Yeah.
Wait. Yeah, because it was April 10th, 2022 at 1:06 a.m. UTC, which... Okay, where are we? Okay. And for all defendants' protests that ABMC should have testified at the hearing, notably absent from defendants' arguments generally regarding subject matter jurisdictions, testimony from Rose that would corroborate defendant's characterization of Discord chat in his declaration. Well, I'm not the person to... What? How am I supposed to try to subpoena this person and bring them?
Keep going, yeah.
Okay.
Yeah, keep going.
A characterization that incorporates in Exhibit C a screenshot of Rose's Discord account that plaintiff could not have obtained on his own from his side of the conversation. And Exhibit C, a screenshot from Rose's... Okay. Thus, as it stands at this stage in the case, the evidence purportedly establishing a definitive timeline as to what defendant did or did not do and when is murky at best. Oof, that's good for me, I think. In any event...
Yeah, kind of.
Do and when is murky at best. Oof, that's good for me, I think. In any event...
Yeah, kind of. All damn it.
Sure. In any event and under...
Yeah, kind of. I'll DM you. Not really. Am I the only one who heard that? Yeah, it's kind of good. I'll DM you. Is that good?
The circumstances, we need not reach a decision on jurisdiction today. Ooh, that's spooky for them, I think. Defective allegations of jurisdiction may be amended upon terms in the trial or appellate courts. They've used, you only get one amendment to the complaint as well, right? So this is it. This is their one amendment, and then we fight here, and they can no longer...
No, I think it's like you should be guaranteed one amendment, and then I think amendments after that need to be subject to good cause, right? I still believe that you would try to get justice as best as possible, right?
I don't believe they can amend the complaint any longer. In any event, under the circumstances, we need to reach a decision on jurisdiction. We don't. Okay. Defective allegations, jurisdiction may be amended. Assessing whether the Court of Appeals is subject matter jurisdiction and noting that plaintiffs are usually able to amend the complaint, even on appeal, when such jurisdiction is deficient. This provision, like...
You know what I'm saying?
Wait.
Is he not going to read this out loud?
Oh, I can't possibly provide that, though, right? Because I'm pretty sure that person deleted their account, right?
Doesn't want to read that out loud? Noticeably absent from defendant's arguments generally regarding subject matter jurisdiction is testimony from Rose that would corroborate defendant's characterization of the Discord chat in his declaration. Do you not know who this Rose person is? Well, he could have argued that before.
Oh, no, wait.
You know what? Wait, you getting it?
Oh, wait, no, I can do... Because I have both sides of her screenshot, because the guy posted them all. Oh, yes. The judge doesn't understand that. Oh, that's so easy. Okay.
Yep.
Yeah. So that's it. That's done. Okay. So I just need... So now it's just the brain damage.
It's just saying, hey, let's
because
move on
what
from
he's
this.
saying...
We can't move on from it yet, but let's...
Yeah, but what he's saying is it would be nice if there was a screenshot from...
I think the rest of us have moved on from this and just said that under this you wouldn't have subject matter jurisdiction, right? I think we've all moved on from this and we're like, yeah, this is obviously they would need other stuff. Yeah, I think they're the only people who haven't moved on from
Rose's
this.
Discord account, that plaintiff that I could not have obtained on my own. What the judge doesn't realize is that the screenshots are coming from her account, so I just need to post them from my side now, and then he'll have both sides of it. You can see there is no discrepancy on the date there. Oh, okay. That's as it stands at this stage of the case. The evidence purportedly listed. Okay. In any event, and under the circumstances, we need not reach a decision. Okay. I've read this like 3 times. Court of Appeals noting the plaintiffs this provision, like Rule 15, leave to amend should be freely granted when necessary to cure failure. They were initially defective. The proper course in this instance would be to grant leave to amend. Based on the record before the court, there is nothing to suggest plaintiff's motion is the result of undue delay, dilatory motive, or is otherwise in bad faith for the amendment to to take leave to amend the complaint. I think is probably true. Hopefully they don't say this on all of them, but okay.
I mean, I've seen from all of the other motions, I don't think there's any evidence of dilatory motive or being in bad faith. I'm sorry, you went and read verbatim from that transcript, my guy. You're clearly reading. Or maybe, hey, maybe that is not like the one-to-one. Dude, I feel like it's very clear he's just reading directly from the transcript, and they allege that he is reading directly from the transcript. If he's reading one-to-one from the transcript, I think he's fucked on that one. I think they will. I think they basically have to sanction him, right?
So you don't know. It is worth noting the plaintiff is incorrect that she timely filed her motion to amend, for which the deadline per was July 6th, 2025. That said, plaintiff filed on July 7th, 2025, and we are loath to consider that single day as undue delay or dilatory motive. And it is true that defendant has been raising the question of subject matter jurisdiction in various responses to plaintiff's motions, and thus cannot be surprised at and should not be unduly prejudiced by plaintiff's request for leave to amend. The parties should have even mutually elected to somewhat pause discovery pending the court's resolution of plaintiff's motion for protective order. Thus, as leave to amend should be freely given in the absence of substantial reason to deny leave. Plaintiff's motion for leave to file her amended complaint is granted should defendant believe, after the filing of plaintiff's amended complaint, that this court still doesn't have subject matter jurisdiction. Defendant is free to file a 12b1 motion or otherwise generally respond. Oh my God. The 12b1 is a motion to dismiss, right? Am I...
Motion to dismiss, yeah. They're saying you can do a motion to dismiss or you can just respond to...
Just to be clear, Destiny has himself talked about and is clearly also understands that he's been able to file a motion to dismiss the entire time. Literally the entire time. He's never not been free to file a motion to dismiss. It's very funny, right? That like he's pretending like, oh no, I can finally file a motion to dismiss. No, he literally talked about why he didn't file one before, even though it was suggested to him. And that was because it would have been expensive. I don't want to just pay for that, guys. It would be a lot of money.
To the actual allegations.
Otherwise, generally, yeah.
And
but now I would want to. Now it's absolutely. It's a time to fight on a motion to dismiss, and then I still get my summary judgment later. For the reasons. Okay, please motion for leave. Okay, plenty of first amendment complaint on the docket. Oh, thank God. Okay, this is about to be my most hardcore research fucking legal reply ever.
Oh, because you're representing yourself, right? As we were.
No, I'm about to send my lawyers like 4 trillion pages of notes for everything.
Yeah, jeez. Yeah, it's good for you. Obviously, they granted it for plaintiff, but
sure,
it's not.
Okay, boom, 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 boom.
All right, don't you have your debate in like 4 minutes?
Yeah, I'm getting all my documents in line.
I guess. Getting all his documents. Was there
freaking
much
out
more
over-
here?
Oh, there's a new.
No.
Oh, I didn't even see that. I gotta read that in a minute too. Oh shit.
Oh, it's our response to them trying to. They want to sanction me $10,000 plus her attorney's fees for talking on fucking food documents. Yeah,
this.
because the Kiwi Farms shit fucking. They're so funny. Oh, and
Because the Kiwi Farm shit? No, because you went on Foodshop's stream and directly read from the transcript, retard. They want to sanction me because of the Kiwi Farm shit. No, that's not what they want to do.
I think we pushed for sanctions in that motion as well.
Has this whole situation hurt Destiny's stream? It seems like it had no effect on his audience. I don't know about that. Was this like his Playboard stream thing? So he was kind of going good for a little bit here, and then was it around the middle of August? He started around the time they discovered the Rose shit. He started dropping to like 5K average, 4K average, 5K average, 5K average, 6K average. He's had some rough streams since. It's been not great. This one was, he got botted during this conversation, or during this day. But other than that day, it's been like, I don't know, kind of steadily not in a great spot in terms of the YouTube numbers. Seems to have fallen off quite a bit in terms of live stream numbers. But it's been since the Rose stuff. The Rose stuff seemed to have hurt him. Apparently, YouTube has also been cracking down on bots. That might be part of it. Oh, interesting. Well,
in our brief to their motion and our response. So that'll be interesting, I guess. Okay. I'm going to use the restroom and then I'll hop in and...
Okay. So that's it for that one. And then this is the next day.
And then looking that it all comes down to now is the Abby stuff.
I think his kick numbers do fluctuate, though. That he would be done for after the CSAM thing. Why? No, literally, people were posting in this community like, child porn doesn't matter, bro. He's still cool. Not even child porn can make me stop watching Destiny. That's unironically a post from Mantis in the community. It's like, not even child porn, not even getting found to have child porn could stop him. It's like, but it should. That, you shouldn't be celebrating that. That should be concerning. That should scare you. That's the weirdest post, okay?
Yeah. You can file for dismissal. I mean, like, it might...
Not even CP can do it. That's what she said.
Pleading and you're accepting it as though it's true. And then...
Oh, so he accepts that the motion to dismiss would not even be... Like, there's no reason to do a motion to dismiss at this point.
If the... That's it. So that's why if somebody dismisses a case on a motion to dismiss, you've probably fucked up quite a bit. So whether... I don't know if we can dismiss it. We'll see.
Oh, it's so much better that we watched it today, and we get to watch the cocky retard from yesterday, and then the destruction of the cope today. Okay. It's way better that way. Let's go.
Depends, I guess, on the Abby stuff. But the MSJ, the motion for summary judgment, I imagine is probably like it should be an easy one, I guess. Again, it's just going to come down to the how much the judge thinks that Abby's testimony with no evidence is, I guess, a matter of fact versus a matter of law.
Wait, is that something that, like, a motion for summary judgment is basically alleging that there are no facts left in contention, right? So if you're not willing to go to trial and produce this evidence, how do you win on a motion for summary judgment? How do you get granted summary judgment if whether or not he sent the video to Abby is still in contention? How could you win a... Am I missing something? Litigious Gamer or any lawyers in chat? I believe a motion for summary judgment is saying there are no more material facts in contention. Can you please judge this instead of sending it to a jury, right? But it seems like there are still major facts in contention.
Are you able to get transcripts yet? Nope, still waiting on the ruling on that. What is the Abby stuff specifically? Destiny, I missed that. I was unaware of this, but when Abby was at my place in 2023, Abby was apparently, after I left, she got on my computer and started snooping through shit. And
no evidence of that. Oh, unless maybe he has evidence of that. He probably does keep, like... maybe there is evidence of that or something, okay? But then why would he not have produced that? I don't know. The evidence that I've seen is basically she takes a picture at his computer and says, big leaks coming, right? Yeah. Sorry, Holy X Grail. She has a text to Darius with a picture at his computer saying, oh, big leaks coming. But then, to me, I don't know why you don't just produce the rest of those logs. Where are the big leaks she did? Surely there must be big leaks, no?
in the process of that, I guess, maybe, I don't know, because I didn't know this until a couple months ago. Supposedly, she went through my folders on my computer and looked at stuff. And
supposedly, according to who? Who said this? Wait, supposedly according to who? Well, I think Moonray Murray, it seems like she's taking a picture of his screen, including like one of his Discord screenshots or something. Like he's got Discord up, sorry. And she takes a picture of that. And so you would assume big leaks coming would be like, oh, I might be taking a picture of something that is leaking. I don't know what evidence there is beyond that, but maybe he's got some. Or maybe that's the only evidence he's got. He's just, to me, he's always been the guy who produces evidence when he has it, right? Like when Willie Mack accused him of having 60 gigabytes of child porn, he immediately pulled that log of Rose saying, actually, we have 60 gigabytes of photo sets. So now he's just like creative writing.
2 months later, there's a DM. This is the only evidence they submitted. But 2 months later, she's like talking to a friend saying, oh, Destiny sent me all these videos of him banging. And then he names Cherry and Pixie, of which I don't even have videos of the former. That's not even true. So my guess is that she just went through stuff on my computer and saw names that she recognized, and she was just like talking shit to a friend. But she's trying to say that I sent her whatever video of Pixie in 2023 or something. But I never have. I don't have any logs of it. They haven't provided any proof of that. And at the hearing, they even said that Abby didn't have any proof of that. They just had that one DM, which I don't know.
This was literally the whole thing. It's not just one DM, but the whole thing was the whole thing was always based on she has contemporaneous messages saying Destiny sent me a video pixie, right? Contemporaneous evidence.
That Abby didn't have any proof of that. They just had that one DM, which I don't know. Can something be hearsay of yourself? Is that possible? I don't know if that's possible or not. No, that's just your testimony. You would testify that this person sent me this video. That would just be your testimony.
And you'd have to account for the fact that you basically have to say that you have some evidence that she looked through your computer. There would have to be something there, right? I don't think he has that.
Why are you asking a question when you either just Googled or you know the answer? Why?
Wait, hold on. What is this PJ forehead?
This person sent me
Call
this
Abby
video.
to the stand and Jizdickle too. Oh, that guy's been in my chat a couple times. Weird. Weird.
Why are you asking a question when you either just Googled or you know the answer? The standard summary judgment is looking at all the discovered evidence in the light most favorable to the plaintiff, correct? Yes. Well, most favored to the movement, against the movement. Are you going to read the amended complaint?
Free Pie, the issue would be, how do you get, he said that the logs don't have those videos, or he didn't send her videos or something, but, I don't know how you prove that he didn't delete things, given they're just one side of his logs.
I mean, I could, I guess. They cut out some stuff and they replaced it with more just like stupid shit, I guess.
Maybe, is there anything else good here, or?
You ever say, I don't believe this person's lying, is what happened? No, I don't think you ever said that.
Whoa, whoa, whoa. Where's Sip Sip when Destiny needs him? God damn it. Start yapping, motherfucker. This is why people settle? Yeah, like, I have a feeling, I don't know if he said it. I'm almost positive he said it, right? Oh, that's what we're waiting for here. He talks about, like, why he doesn't want to settle. But, I think his lawyers told him, just settle. Like, you should just settle this. I think they knew it would be, like, insanely expensive. And they're like, yeah, just settle it. It's obviously worth it to settle it. Like, she has some claim here. Don't risk this getting in front of it. It's like, just settle it, bro.
Can you directly say in a filing, I believe this person is lying, this is what likely happened? No, I don't think you would ever say that. I don't need to say that. They have no, it's the onus is on them to provide evidence for their claim, right?
Well, I think they're trying to provide evidence to get discovery, right? Is what they're trying to do. They're basically saying, like, this would be discovered through seeing the Google Drive. Oh, hello. Hello.
Comes now plaintiff Jane Doe, buying through undersigned counsel of the plaintiff.
He's going to reread the whole thing?
Another Florida laws pertaining to rights, privacy, public disclosure. The already face in this complaint and publicized on our own social media feeds, but okay.
Not with her name, though. Which is obviously a little different.
And then defendant Stephan Bonnell II. For some reason, they are still misspelling my name. I don't know how, but okay. It's a citizen of the United States and a resident of Miami Beach, Florida. Bonnell's a live streamer and a political commentator. He's over 840,000 subs on his YouTube channel. He's huge following X, Kick, Reddit, and Discord. Bonnell had over 700,000 followers on his...
Hold on. He can't handle the reputational damage. Like, the damage is there, but he can't internalize it and accept it. Yeah, I think the issue is he had like a thing where he didn't want to be known as like some sexual like weirdo, right? He wanted to be a sexual weirdo, but not be known as a sexual weirdo. And now he's going to have that reputation for the rest of his life, and I do think that's like quite frustrating for him. Like that's probably another reason he can't settle, right? Is he wants the win in court, and if he doesn't get the like, he's just gonna ride it out for the win in court to try to say like, yeah, I won, so you can't call me this anymore. But even if he wins in court, he still was sending the video around, right? It's still like he is still a total fucking weirdo. Like I don't think the reputation ever heals at this point, like because of what's bolted on. Also, he didn't want to be known as a sexual weirdo, and then he helped and was the key evidence provider in doxing the minor he was sexting. Like that's sort of the reputation's gone at that point, right? It's just over.
The Twitch channel before was banned from Twitch in March 2022 due to hateful conduct. Nice. Plaintiff, known online as Pixie, is also a live streamer as well as an info followers. Log of my birthday, and I don't understand. Remember, actually links keep with the link or anyone in your organization, but I'll trust the least restricted privacy setting for his Google Drive link. Anyone with the link, this setting makes the sensitive material accessible indefinitely to any third party possessing that link. This ongoing accessibility functionally equates to publicly posting explicit content online. If this was the case, that would mean that literally every single digital thing that you send counts as being published and forever online. Because
no, only things that don't have like privacy settings. I do think that there's already precedent on this that sufficiently unique identifiers will essentially count as a password, and that those won't be considered publicly available. So when you create a public Google Drive link, it adds this UUID to it, this universally unique identifier that basically counts as like a unique code that makes it unlikely anybody, he argues the same. There's literally precedent on it. We looked in when the case first got brought, we looked into that case. I think it's LinkedIn, some like LinkedIn case. Is it LinkedIn? And there's another case with like somebody had like a Google Drive link that got exposed through a Facebook post, and somebody like grabbed those materials, and the argument was, oh, they hacked that. And the guy who used it was like, no, I didn't hack it because it was publicly available. And then it was declared like not publicly available, right? Because of the uniqueness of the URL. I think that is basically, that's precedent somewhere. But the issue here would be if that drive was there, then obviously he could be linking other people to that drive after the fact, which would be linking it without linking the video directly. And I think that would count as continuous publishing. If I link a Google Drive URL that is a folder, and that folder has the Pixie video in it, that would count. So they might also be arguing that.
Like if somebody has a link or a file, it literally doesn't, like it's the same thing in effect, right? But okay.
It would have to be from some non-normalized like URL structure. But that's Google Drive is a UUID, so I think you're safe there.
The there is court precedent that people have tried to make this argument in the past, and this is not a real argument, but
oh, there was I think there's a possible reading of the precedent that could still say this doesn't count, but I can't remember what it was now. I watched it and I'm like 95% you don't get to make this argument that by creating that URL you're making like you're publishing and making it publicly available. I think 95% chance you can't say that, right? But sending the URL to people would be another instance of publishing or disseminating. And then that would be in like the video case. In the video case, in the folder case, that would be big bad. That would be continuous publishing. That would be because you'd be linking the video or folder that contains the video every time. If you just had the URL for the video link, I think that still counts as essentially private. That's not really considered different than a file itself, like directly transmitting. Like if you directly transmitted it to one person, and they directly transmitted it to somebody else, those would be two independent events. It wouldn't be like it's publicly available because it's sitting there as a URL in somebody's shit. Yeah.
Well, I guess they want to try to make this one. They've walked back the initial date to saying, based on the available evidence to date, it cannot be conclusively determined whether Bunnell's dissemination of the video to Rose occurred on April or October. So the date here is important because if it's on April, then this law isn't in effect, and they have no case.
They would have a case of the Abbey. You need all three dominoes to fall. The Google Drive continuous publishing thing, that you didn't send the like a folder link to people that contained the Pixie video. And I think they probably do have some evidence to say like, yeah, I think you would have sent a folder to people, right? I think they would have that evidence. What else is there? And then there's two more. then the Abby stuff, and then the date on the Rose stuff. The date on the Rose stuff, that domino falls for sure. I'm almost positive.
There's not a real contention here, unless they legitimately think there are 27 months in the year. This is not real. They try to get ahead of this Google Drive link, and they try to say that even if it was just sent as a video file on Discord, even if it was not sent via a Google Drive link, but was sent via a media attachment on Discord, it would still have been continuously accessible. Discord automatically creates a link, and anyone with access to that.
So that is something that could be so continuously accessible. You could make this argument. I think they can't possibly rule as precedent that having the continuously published like link perpetually in those DMs. I don't think you could make the argument that that's like that counts as continuous publishing, or else basically every like folder, every video you send is continuously published if you have the ability to delete it or something.
That link can access the video. Every video sent on Discord automatically is embedded with a media attachment link. This link is a live link. Defendant has demonstrated knowledge of this feature because he routinely shares Discord media links in his public chat threads. The same analysis applies to both sharing the videos through Discord or sharing the video as a Google Drive link. Again, this argument is like immediately, well, hold on. If I were to share a digital file with somebody, they could just spread the file just the same as if I were to share a link with somebody. Like, it's the same thing. This is a nonsense argument. And again, there's already...
So the argument here would be the publicly accessible link. The counter argument, it's still a UUID even in Discord. So I believe that that does not count as a publicly available URL. Like if you publish to Destiny's really cool pornfolder.com and you could just see everything there, that would be publishing, right? But like you're basically using like a string with like as many combinations of that string as exist like atoms in the universe, right? So it's like just because you have one of those strings doesn't mean somebody could type it or guess it or get into it through inference somehow.
I think the case law I've seen that counteracts this is I don't remember if it was a 9th Circuit case or an 11th Circuit case. I don't.
That is what they're looking for. Free specific is the ability to subpoena Discord and Google Drive. Yes. Yeah, that's what they're looking for.
In this circuit. Is Florida the 5th Circuit or 4th? What circuit is Florida in? Oh, 11th. Oh, maybe it was an 11th Circuit case then. That's good for me. Oh, for being crazy, what the fuck? Texas 5th Circuit, right? 1, 2, 3, 4. Oh, 5, 6, 7, 8, 9, 10, 11. Weird. Okay.
I read this case when it came out that he's talking about with URLs and why they don't count as public dissemination.
Also, I don't even think this is true. They haven't submitted any proof of this. I don't think there's any proof of this. I don't think I did a link here or whatever, but anyone with a link can view it. No Google account or sign is required, and agree with anyone else. Thus, final disclosure of the video to Rose was not just a one-time event, but rather constituted ongoing dissemination. I think that they have to be very, 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 very careful with this argument too, because I think if they run this argument down too hard, then the argument would literally just be that, because I do know that the way that I initially sent my stuff back to Pixie was just setting her Google Drive links. So if we're going to make the argument that that counts as publishing online, then she consented and acquiesced to it immediately when she received them. Like, so that this argument is just so stupid. I don't know why.
I don't know if it applies both ways. Like she received the link from you. I don't know if it applies to both ways. Yeah, I don't know. I kind of see what he's saying there. That like, oh, if you're going to argue that should be known as publicly disseminating, that I sent it to her with something that's publicly disseminated, why didn't she freak out about it? I don't think you could say she consented just because you sent it that way.
Oh, well, I didn't know why, because they're desperate, but whatever.
I think that's really rough for him, though, okay? I actually don't know why Pixie wouldn't have gotten, like, kind of freaked by that. Wouldn't you get kind of spooked by that? Wait, why do you have that on, like, a cloud drive? That actually is kind of crazy that Pixie didn't get spooked by that. And that it's on something, like, that would be, oh, shit. Wait. Dude, if he had an openly permissible link there, that might really fuck him if there are access logs for that link. That would be really rough for him, I think.
Sometime of March of 2023, Bono began messaging with a fan on his on Instagram with the screen of Abby MC. Over the course of their ensuing relationship, Bono sent Abby MC multiple sexual videos to the Google Drive link. Videos of Bono sent to Abby MC on the show Google Drive link included one of the videos of Plaintiff. There's no she was uploaded as pics and insanely disgusting. I don't know why this stupid fucking idiot keeps putting like all of this shit just in public filings for literally everybody to like. It's just the most outrageous, stupid fucking thing. This is like one of the most. This is why I don't believe the suicidal claims or any of this other bullshit that she's saying.
Yeah, I don't know if Destiny realizes this. Pixie doesn't write these. Yeah, he's like spurging at Pixie. Pixie literally doesn't write these. I don't know if does he think, is he writing pages or is he writing documents for himself, or why does he think Pixie's writing this shit?
Like, this is just a deeply unserious way to approach. It's just deeply unserious, but Solo Tiny Leaks stated online that he accessed the videos that he posted on KB Farms from links to Bonnell's Google Drive. If I get Solo Tiny Leaks, he was able to access the video and then distribute it. Confirms that Bonnell's disclosure via an unsecured Google Drive link with the broadest possible privacy setting. Enabled ongoing continuous distribution. And we're not one-time events. Literally, anybody that accesses anybody's digital device has access to every single digital file on that device. Like that.
No. Wait, but he didn't. Nobody accessed her device. It's on the account. It's literally saying it's fine. It's fine. You'd have access to the messages. I guess. Sorry. He said device, and he didn't have access to the device. But it is it's the account that had it. So yeah, even if it was a file, the file would still be there. Sure.
That's like, I don't know actually why I keep saying digital. This would be.
I would say that if he ever linked something like a folder to somebody that included the Pixie thing, that would count as continuous distribution as well.
If I gave you like a Polaroid, like if I gave you a picture. Like if I gave you a Polaroid picture, would that count as continuous publishing? Look, it's such a stupid argument. Shortly after the video was posted, various friends and random followers of plaintiff informed about the dissemination video. Some of the messages are very accusatory. She is shocked, humiliated, and mortified by the dissemination of the sexually explicit video. As of today's date, the video has been, just keep talking about the websites. Nice, go jerk off to my shit. All right.
Oh, this is also true though, that yeah, you could restrict the Google Drive links too. To like an email or whatever. That would be, dude, I feel like, I don't know why you would get an unsecured Google Drive link of porn that contains you and just go, this is fine. That seems fucking insane to me. Like, really, really dumb on Pixie's part. Like, obviously gross on Destiny's part for doing that in the first place. I would just be like, bro, what the fuck are you doing making it like a publicly accessible link of this? Are you out of your fucking mind?
All right. On the evening of November 29th, 2024, plaintiff sends a message to Bonnell on Discord expressing her horror. They share the video of her. She asks him if he sent any additional pornographic videos to anyone. He admits his guilt. Okay, not really, but we'll get through that, I guess. Plaintiff asks him to delete any and all videos that he has of her.
Oh, hold on. I've had phone combos and stuff with this person. They were fairly close to me. It's worthless to say, but at this point, but I'm super sorry. There's literally no excuse. There shouldn't be no. I'm so sorry. There's literally no excuse. I'd had phone convos and stuff with this person. They were fairly close to me. He met them max 10 days earlier for the first time. Spoke with them in DMs for the first time 10 days earlier as somebody he had no affiliation with, no association with. Yes. This is just insane, and it's a window into who he is as a person, right? This is like an insane, absurd lie to tell somebody. And like I don't know if he would even admit that this is just an obvious lie. So did he lie in court about this? I don't know if he's responded to this quote specifically. Dude, it's so crazy that he just makes shit up like that. The video goes
viral and is being discussed by thousands of followers of Destiny Pixie on various platforms, including YouTube, Discord, Reddit, blah, 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 blah. Plaintiff begins receiving messages. Many of the followers discussing the leaks on the different accounts falsely claim that plaintiff exchanged sex for professional growth and favors from Bonnell. Okay. Plaintiff feels increasingly humiliated, mortified, and depressed and starts feeling suicidal. On or about December 11th, 2024, she starts writing suicide notes. Plaintiff messages Bonnell and tells him that she is just tired of living anymore. It's a matter of time until my family discovers what happened. I feel like the best thing to do is for me to kill myself and schedule a post just detailing my feelings on what happened to try to ensure a situation like this doesn't happen again. Plaintiff then unfriends Bonnell on Discord so that she cannot receive any messages from him. I like how she doesn't admit that she asked me for money to make it so this didn't happen, which is extortion, by the way, but okay. On or about December 13th, 2024, suicide risk. On or about December 13th, 2024, plaintiff meets...
Why would she mention that? It's her complaint. Why would she mention that? Wouldn't that be really weird to mention in a complaint when it's unrelated to this thing? I just feel like that would be really weird. Who confesses to other crimes in a complaint? By the way, I also committed a crime in a complaint. Unrelated crime. I just committed a totally unrelated crime, guys. Yeah, I know it's weird to put that in my complaint, but I should put it in my complaint to be intellectually honest.
Bonnell's close friend and business associate Colette Turner. Plaintiff tells her about her suicidal thoughts, that she cannot bear the humiliation and harassment she is enduring, and that she wants...
Really, Destiny? You're just gonna dox Not So Erudite live on your stream, Destiny? You're just gonna dox Not So Erudite? That's crazy.
Wants to ensure Bonnell never does this to her or anyone else ever again. Yes, by being forced to give her $1 million.
Guys, this is absolutely fucking disgusting. Oh my god.
But I guess she doesn't mention that. Okay. Turner tells us she will talk to Bonnell and tell him what they discussed. On or about December 19th, Turner asks plaintiff if Bonnell has communicated with her or added her back as a friend. Plaintiff responds in the negative. Plaintiff continues feeling depressed and suicidal. Like the video is still a viral topic of conversation on multiple platforms. This is not true. People are not talking about her video at all. With people making
This is just wrong.
horrible accusations about plaintiff. On the morning of January 20, 2025, 2 videos on YouTube were posted by 2 different streamers discussing the Pixie leak. The videos include screenshots of private messages of plaintiff discussing the situation with friends, and claims that plaintiff took hush money, only cares about money, and does not care about the other victims of defendant. These videos have been viewed by thousands, including one, which of today was viewed by over 90,000 people. The majority of the posts by people assume that Bonnell shared the videos with plaintiff's consent and knowledge. On or about January 2025, in desperation, this is a fucking lie. I've seen her DMs with Aaron, like they're publicly, you can see them on the videos. She had already crafted her statement at least a week earlier. So this wasn't out of desperation. She was always planning on doing this, but she pretends that she was forced by these videos. Plaintiff.
Wait, both of those things could be true. Why does he pretend to not understand that both of these things could be true? Right? You could be planning to sue him as like a last ditch effort, right? There's nothing to even know for sure that she wouldn't have reached out again to be like, hey, I've like retained legal counsel. I'm gonna try one last time to see if we could solve this in person or solve this through some other means, right? Like, there's no reason to say just because she crafted her statement and looked into legal counsel that she would have sued you no matter what. But she was pushed to by the videos breaking.
/Pixie goes online and announces that Destiny share the videos without her consent or knowledge and that she'll be seeking legal recourse. That same day, Bonnell says a response on various platforms, including Reddit Imager, and falsely claims that the video leak happened without my knowledge, consent, or authorization. They're trying to play this weird game where, like, when I say leak, obviously I'm talking about the guy that fucking posted 30 fucking porn videos online, and they try to say leak is just sending the video to anybody, so they play this word game back and forth a lot. This claim directly contradicts his November 29th, 2024, explicit written admission to plaintiff that he knowingly and intentionally shared the video with Rose without plaintiff's consent. That is not the claim, but okay. On January 20th, right after plaintiff announced publicly she would sue Bonnell.
Claim directly contradicts his November 29th, 2024, explicit written admission to plaintiff. Oh no, you did this twice. You actually like acknowledged to multiple people that you did this.
One of his followers, and she still includes all these weird.
It's like, by the way, this is so much worse than his like walk back of the Rose pornography sharing. This is actually so much worse that he, like, in multiple conversations with multiple people, basically admitted he shared it without consent, right? Without knowing if he had consent, without certainly without an explicit conversation about consent.
Weird hearsay or double hearsay things, even though they have no evidence of this. And in a hearing, they said that all these people deleted their accounts. On January 20th, right after plaintiff announced publicly she would sue Bonnell, one of his followers reached out to plaintiff and told her that Bonnell had.
Hold on, just to be clear. You're basically right, Tequila Sunset. You're in effect right, but Eric confirmed to Turkey Tom that she asked Dusty if he had consent, and he said, I don't think so, no. Like, I don't think so. So it was one of those things where he always leaves, like, a little bit of plausible deniability there. I don't think so. I don't think I did have consent. I don't think so. I don't remember for sure, but I don't think so.
Sent the video to her sister about 2 months earlier. The follower informs plaintiff that she believes Bonnell is in.
Oh, they left that shit in there.
To share the videos by message to people.
Okay, we need to get through this because I want to get to the actual part where he talks about not this.
7 years ago, but it was just showing that she was trying to fuck me. I wasn't trying to do any weird shit, but the fucking Kiwi Farms and no one is doing anything about it. Yeah, but good one. The videos disclosed by Bonnell were of a private nature, were never intended for public distribution. Defendant's actions will cause plaintiff severe emotional. Blah, blah, blah. Okay, and then this is just the Jesus. And forgets who Dylan Burns is. I saw that clip earlier. What do we got on the docket for today? Wait, horse crotch snake. Do you have any proof of that? Or, Abby MC is being squirrely with Jane Doe's lawyers because she's trying to get compensation for her testimony. She doesn't want to do it for free.
That's, by the way, just a perfect window into his mind, right? Is that not a perfect window into his mind? He's like, wait, do you know that? Like, wait, is Abby really trying to get money from them? Like, he's hopeful of, like, any positive news at this point. I'd say that's like a window into how well things are going. Wait, random chatter? Do you have evidence about my court case that would save me? Random chatter? Oh my god, horse crutch thing. Well, what was it? Horse crutch snake. Horse crotch snake. Do you have evidence that would help me? Please? Amazing.
This reads more like an attempt at cancellation with the amount of random shit in there. Yeah, I mean, that's basically what they're doing. They're just trying to, like, throw random shit in. But, like, again, the only thing that really matters now is the Abby MC thing, which is who the...
I find it so funny that he talks about how disgusting Pixie is, but at the same time, he did so much more to hurt his own reputation by doxing Rose, by being the number one information provider for doxing Rose, right? Like he could talk about how disgusting Pixie is and how she's like tried to ruin his reputation, but he ruined his reputation so much more by proving that he was sexting a minor than anything Pixie has done or could have done. Right? Everybody was willing to write Pixie off. Okay, Destiny he'd laid the groundwork for that same defense. These people are mentally ill whores. He'd laid the groundwork for that 1,000 times in the past. He was skating. He was on easy street for that one, right? And then he had to go and prove to the world that he was sexting a minor and lying about the amount of information he had for finding her. It's incredible. Because I think later in this, he'll talk about how Pixie's the most disgusting person he's ever met. She's just totally disgusting. And it's like, bro, she couldn't do, with all of her power, the might of $50,000 and the outrage of like the entire internet. She couldn't do 1/10 of the reputational harm that you did to yourself by doxing Rose.
I don't know.
It's incredible.
If she actually...
He can never go low in a debate now because they'll just call him a pedo. Yeah, that's the thing, is like, he's like kind of eternally cucked now. He just gets to be a eunuch for like the rest of his time on the internet. Like, he was able to get back at Ethan, right? Because Ethan has a 20-year career where Ethan says insane shit. But for most of the people he talks to, especially in politics, he doesn't want a bunch of clips of people laughing at him and calling him a pedophile, right? Like, that was the last thing he wants with Taylor Lorenz. He doesn't want Taylor Lorenz laughing at him and asking, did you really sex a 17-year-old? Did you really prove that did you really, dox her and with Kiwi Farms and prove that she was 17? Are you a fucking moron? Right? So he can't be rude. He can't be rude. The Wick Dono clip? Wait, are you talking about the Molina one? He's talked so much shit about Taylor Lorenz, but in the call he was so soft? Yeah, I know! It's amazing.
Actually did get brain damage from that car accident, and that's like explanatory of all her behavior over the past year and a half. That would be really sad. It would be even more crazy that Pixie's taking advantage of her to try to keep her case alive.
Dude, this guy... No. Abby had Abby's got like a lot of stuff going on. She had like addiction issues and stuff, and it's pretty well documented online. And it's like, it's sad, but people were taking advantage of her the whole time, including Destiny, including this guy. And then he sits here and he's like, it'd be really disgusting if Pixie took advantage of her more than I took advantage of her by flying her out to Miami, Like, bro, you can't sit here and concern troll about people taking advantage of someone who's mentally ill when you flew that person out and fucked them. Like you can't do it, right? You can't concern troll about this and about her mental illness, right? She can make decisions. She has agency. It's so performative. She can make those decisions. She can decide to fly out to you. She can decide to sue you. She can decide to give testimony to Pixie. She can do those things.
Alive. Just intuition. Oh, good one, buddy. What about the dismissal? Well, I imagine next, I think we try to file a motion to dismiss. But again, on the pleading stage, the judge is supposed to read all the facts of the complaint as though all the facts are true. So it would be surprising if he dismissed it here, but I don't know. We'll see. The fact that...
But Destiny, I thought you said that it was obvious he was going to dismiss... Sorry, not obvious. That there's a chance he'd dismiss it himself without even a motion. I thought this was getting dismissed. Bro, what happened? Listen, guys, in a week or two, this will be dismissed. It'll all be over. Record scratch. Cut to 6 months later. I guess you guys are wondering how I ended up here. Well, it's quite the story, okay? It's quite the story.
That he invited one, I think, is nice, but...
That he invited one? Did he invite one, or was he basically like, stop yapping about how there's no subject matter jurisdiction if you're not going to move to dismiss, loser? Like, it's pretty obvious he knows that there is subject matter jurisdiction here, and you should just shut up about it. You should stop putting in your pleadings. But he's basically like, if you want to solve this question, file the correct paperwork to solve this question. It's actually the same thing that happened to Pixie when she went to the TRO hearing. When she was like, I actually want an order saying he can't destroy evidence. And they're like, hey, bitch, you already got one of those. And if you want to sanction him or if you want to do something, there's like other things you should do. There's totally different procedures you should follow. Yeah, it's he's just doing... The judge is doing that same thing to Destiny now. Different judge, though.
So did the gag order not work? There is no gag order. They were kind of asking for effectively what would be a gag order, but the judge noticed that they were being tricky with the for effectively what would be a gag order.
Okay.
But the judge noticed that they were being tricky with the the judge noticed that they were being tricky with. They sent us a motion to agree to, and then we did, but the one they filed with the court was completely fucking different. So the judge denied that one and granted, basically the motion is granted in part, just like an ordinary protection order over discovery information. So
I don't think they made any ruling on the public speaking. I don't think they made a ruling on that. Is he trying to imply they made a ruling on that? I think that protective order with regards to public statements, I think that motion is still alive.
So whatever we trade back and forth in discovery, we can't like post publicly. Especially in a case like this, I mean, it's kind of fair, yeah? Can you expand on your take on the Google Drive link argument? Why is whether the link is public or private not an important difference? Because having a link is the same thing. Like a file is basically the same thing. It's all just digital data, right? Like if you send me a Google link, it's not really, I mean, except for maybe through some maybe hack, but like let's say you send me like a link to a file versus you sending me the file itself. My ability to transfer that file to anybody else is the exact same, right?
No, technically you can put it in other places. It's like every platform allows text, not every platform allows attachments. There's probably like a bunch of different reasons why a link would be easier to share, why a link would be more meaningful to share. But like, what I would say is I don't think having that link, the existence of that link is not proof that somebody could find it through the broader internet, that it is a continuing publication of that video, is more where the argument has to go. So he's trying to make that argument. I don't think that argument is quite as good. The argument that he's probably referencing that there is case, I think there's already existing case law, existing precedent on, is that a unique identifier in the URL is basically going to make it so that that counts as like something sort of password, semi-password protected. That the privacy setting is not necessarily like open to the public as if you publish it on a website in the same way.
Like say you send me a picture of your mom versus sending me a link to a picture of your mom. It's the same thing. You can do the same. Like, did you say?
Yeah, this is also true for specific. Yeah, this is also true. Like, and I would say because it's being put into Discord, in Discord, you can actually, for all of the exporters, you can export without videos, without media, or with media, right? There's like a whole bunch of reasons it would be different.
Send him my thing? Oh, no, don't worry. I didn't send him a thing. I didn't send him that thing. I just sent him a link to your thing. It's like, oh, okay, thank God. But the funny thing is I think it was an 11th Circuit case. There was a case where somebody tried to make that argument because somebody apparently messed up and posted a Google Drive link publicly. I think they posted the link publicly and
there was a link on a picture in the background of some photo they posted on Facebook. And then somebody accessed that and everybody said, well, it's not hacking because you made it public. And it's like, well, because it was like publicly accessible, the privacy setting was set to public. And it's like, well, the URL was sufficient such that nobody could find it. So to say it was public is not really true.
Included the link up top and it was a public link. And then but the judge ruled that didn't count as public disclosure because I don't remember what the argument was, but even that didn't count as public disclosure. So
I've given it to you because I actually read this stuff. No, I actually just got lucky and read this one because
Are you able to say why you believe they deleted evidence? Pixie? Because she knew she was trying to extort me. And my guess is going to be that Lauren and her were probably going over the conversations and Lauren probably told her, you have to delete this part because this is like, there's a reason why there was.
Let me just, sources cited, crack pipe. Sources cited, just a big old crack pipe right now.
A specific dollar amount brought up with me, I think. All she complained about was that because the thing in her first message was, one of the things she said when I said if I could help or whatever, she said, I think that what was it? It's in the mini fest I read about this. She said that I feel like any dollar amount that I ask for, you're gonna say no to, and that's just gonna make me feel even worse. And that's the message that she deleted. Maybe because it's the one that came the closest to like bringing up a dollar amount to me. But my guess is Lauren told her to delete that message. Yeah. Also, when I looked at it, it's funny actually because I think a hater posted this or sent me some DM, and I didn't realize this until way too late. I don't think I even.
Oh, this will be the argument.
That I don't think I even sent that video as a Google Drive link, so none of that even.
Dude, I pointed that out the second they made that argument the first time. No, they obviously posted it as like a Discord. You obviously posted it as a Discord attachment. Like that's obvious from the text messages from the export, right? He didn't send a Google Drive link with the Pixie video. He literally sent the video. He like uploaded the video.
Even applies to this, so it's all moot. But even if it did, it's all this is stupid, yeah. How did she even come up with 15 fucking million? I have no idea. She took the statutory maximum and multiplied it by 100.
15 millions.
100?
By the way, he's like, I would have maybe paid her like 50K or something. It's like, bro, to litigate this case, she has a case that would have subject matter jurisdiction that wouldn't just be dismissed, that she's got evidence that she could go to court with. It will cost you so much money. That is a part of, unfortunately, settling a court case. It's not really fair, is it? It's not totally fair, but it's like, what would it cost you to defend yourself here? Is there a case, right? And how much would it cost her to prosecute the case? Well, unfortunately for you, like, it's not going to cost her that much money. It's going to cost you way more money. And then you hired the most expensive. He's like actually fucked himself by hiring the most expensive lawyer he could. I don't know that Andrew Brettler's like saved him in any way up until this point. I don't know that it's like necessarily helped over just any random law firm. But he's paid like probably double what you pay a standard law firm. It's like, if you're going to take this to trial, if you're going to refuse to settle, why not pay somebody who's not going to charge you like an arm and a leg every time you file a motion?
I still think you would have been better off paying her off.
Alpha Kilo, just so you know, we've already said it, okay? Pixie's lawyers, Joan Schlump Peters, if you can hear this, okay? I'm calling out through the ether, through the Cabal telepathic communication network, okay? The Cabal telepathic communication network. Joan Schlump Peters, can you hear me? Joan Schlump Peters, can you hear me? Can you hear me? I hear you. I hear you. Joan, I hear you. We've formed the connection, Joan. I need you to file in what they call an errata, okay? An update of an erroneous filing. Yeah, you've stated Rose is 19 in your amended complaint. You need to update her age. She was 17. She was 17, Joan. Joan, she was 17. Joan, you have to update it. Joan, you must update it, Joan.
What, paying her $1 million?
Oh, Alpha Kilo, all that is to say is they say it's a 19-year-old named Rose in the complaint, and they could just update that to a 17-year-old. That should be on the record, for sure. Yes, we do need that on the record. Joan, please. Joan! I think, I'm pretty sure people who watch this stream do email Joan sometimes, so listen. SS, if you're hearing this, I need you to send another email to Joan and just make her aware that 17 should be age on the record, okay? Should be the age on the record. SS, if you hear me now, okay, if you're watching the VOD tomorrow morning, SS, this is a communication we...
$1 million? Fuck no. That's crazy.
Hold on.
I still think you would have been better off paying her off. What, paying her $1 million?
I think for the reputation hit, yeah. He might have gotten out of this. He really might have gotten out of this entirely. If he just paid like her $1 million off, 500K each or something, right? And maybe Stasha too. Well, fuck. Stasha deserves to get paid for that, right? For the violation, and she deserves that. I think Pixie and Melina were the people with platforms and the people who his fans knew, and the people who, if they weren't speaking out against him, he might not have any issues. I think those were the ones. Millie, to keep this all behind the scenes. If he could spend $1 million to keep this all behind the scenes, or mostly behind the scenes, right? I think he should have, and I think it's insane to say otherwise.
Fuck no. That's crazy. Is Lauren just out of any interactions? I haven't heard about her in a long time. She's just a weirdo behind the scenes.
By the way, I just want to point out that Zip knew 100% that filing to dismiss was retarded yesterday, and he didn't point it out because he didn't want Destiny to be mad at him on stream. So why Destiny came back today and was like, yeah, I don't think we get to dismiss, guys. I don't think that'll work.
You're going to come out of this whole situation minus $1 million anyway. No, so wouldn't it make sense to settle outside of court and avoid all this bullshit? I don't think I'll get to that level of expense, hopefully. By the time it's all said and done, hopefully we're under 600K.
How is he spending 95K a month, but he's under 600K?
Which is still pretty gross. But I would pay 600K to prevent her from getting 100K or whatever. That would just never...
Oh, it's good to see not just his politics are spite-based, okay? Spite-based accounting? Spite-based monetary decision-making? I would spend so much money to prevent her from making any. Bro, this is your king of like facts and logic over here, apparently. My God. Maybe only 1 month was 95? Yeah, probably.
She's the most
Probably.
disgusting person I think I've ever interacted with at this point in my entire fucking life. Like, I'll burn through some cash to make it.
Who is the more disgusting person? Nick Fuentes or Pixie? Obviously Pixie. Bad Empanada or Pixie? Obviously Pixie. Pixie is a terrorist and a white supremacist. She's a Nazi and a terrorist and a doxer and somebody who threatens people's lives all at the same time. What a fucking bitch. The most disgusting person I've ever dealt with in my entire life.
So she's not getting any. Especially if knowing that the way that this all ends up.
Oh, he dealt with MSG. Also, she's a pedophile.
And seeing all the filings, like, she'll probably get dragged by the end of this too. So fuck her. Like, I'm okay with that. Her behavior's just been abhorrent. Why would I reward that, right?
Because you'd be saving yourself, cutting your nose off to spite your face. It's transparent.
There might have been also, I will say though.
This is what happens, by the way, when you have like a cult of personality. You lose touch with reality so badly that you like just start saying shit. You just start like, you think you can weave reality. Like you fabricate reality and people just like clap like retarded seals around you. Isn't that terrifying? I feel like I have an ego, but I've almost always had friends who will tell me that I'm wrong on things. And I like prioritize keeping those friends around because I'm always worried about like letting my ego get inflated. Like I think I've been pretty consistent about that in my life. Like always trying to make sure I have at least one or two people around me who will be like brutally honest with me. And I just can't imagine getting to the place where you only have fucking only have sycophants. And you like think you're just correct about everything all the time.
Though there might have been some wiggle room for some kind of negotiation, but she destroyed all of that when she posted the Substack.
Substack.
As soon as she posted the Substack, her chances of getting anything were deleted. But my guess is she's probably from a rich family anyway, I guess. If she can waste, because you know she's not spending.
He knows she's not from a rich family. He literally knows. Bro, you were on a call with her dad. Did it look like they were living in a rich area? Remember when Pixie's dad got on a call with Destiny and Pixie and was like, "Thank you for taking care of my daughter. Thank you." I don't know why I did his voice like that, okay? I don't know what the accent was. I'm not even we're gonna move on, all right?
Her legal fees at this point must be in excess of 50K, and she hasn't mentioned anything publicly about spending any of the money that she fundraised. So my guess is,
well, she spent the money that she fundraised on lawyers.
her parents probably are just paying for all of this. It's a family friend, family favor, and then she just pocketed the 50K because she doesn't make any money.
More creative writing. My guess is they're going to take this pro bono, know that she got 50K through a GoFundMe, and they're actually going to take no money to work on this case. That's my guess. That might be the dumbest guess I've ever heard in my entire life. Oh, right. Dude. Yes! Aaron literally told Destiny. Yeah, this bitch is hard up for cash. She can't even afford podcasting equipment. Destiny knows this. Possibly Teeny Tiny Tony. Destiny will, in all other cases, understand that money is fungible, right? That if she has to spend 50K on... So he's got to make up that, like, she's, I guess, getting this stuff pro bono, even though the lawyers would know she has, access to funds explicitly earmarked for a legal case? I have no fucking idea. Yeah, it makes no sense, right? And the funniest thing about that, like, stupid fucking food shops theory is she was comparing it to Keffels, who's spending a bunch of money on, like, gifts and travel and a new place, like a full year lease. She paid, like, her rent up front. There's, like, no evidence of a court case, no evidence of any action with lawyers, and every piece of evidence that she was spending money, like, hand over fist. Pixie, she literally immediately filed. She literally immediately started paying lawyers to work for her. Although, apparently, Brianna Wu found the first lawyer, I've been hearing.
Online anyway, it's my guess. The New Yorker.
Brianna Wu found Pixie's first lawyer. I thought that's what Destiny said. Destiny talked about this on like a or sent food shop some shit.
Thrashed for inviting pro 9/11 radical Hassan Piker, who called Israelis inbred, to speak at festival.
More evidence that people would rather associate with the guy who said 9/11, America deserved 9/11, and the guy who totally... They could believe everything, that he's a massive anti-Semite, that he supported 9/11, that he hates America, that he supports terrorism, and they would still rather hang out with Hassan Piker than Destiny. Unlucky, buddy. Unlucky.